If the federal immigration people, the ICE, Immigration Customs Enforcement, if they come to your workplace and they say, we want to come in and inspect your manufacturing floor, or we want to come walk through the office. In the past, if you wanted to be cooperative, and sometimes the advice was, please be cooperative. If you wanted to be cooperative and let them in and walk them through and give them the little guided tour, you were allowed to do that. And again, sometimes the advice was that you should do that so that they don't come back and decide you're a big target. Well, now California has passed a statute that says you are not allowed to volunteer to let them in. You have to force them to get a warrant. Now, on the one hand, you know, as a lawyer, I'm not a fan of just letting the government come in and just roam around. And if in California no one's allowed to come in without a warrant from ICE, then I'm not going to become a target by saying no. So I'm kind of like, okay, fine with that. But now you need to know you cannot voluntarily give ICE any sort of access. You cannot let them review records without a subpoena. So if they make a request to see all your I-9s, your records, what have you, you have to go, you got a subpoena for that. And they're going to have to go back and get one. Now, presumably because they know about this law, they may just show up in the first instance with a warrant or a subpoena. But one of the other things that you're going to have to do is when you do find out that ICE is knocking on the door, you have to give a notice to your employees.